A Washington state man now awaiting charges in the murder of a woman he met online. John Robert Charlton accused of killing and dismembering 40-year-old Ingrid Line in her Renton home, then driving her remains to Seattle, where Line's dismembered body was found in a recycling bin the following afternoon, hours after she was reported missing. Let's talk about this case with our legal panel now. Eric Guster, a criminal defense attorney. Bob Bianchi, also a criminal defense attorney, trial attorney, and former head county prosecutor. So, Bob, the suspect in this case, John Charlton, has said he got too drunk, doesn't remember anything about what happened on the night the two were together after they left the Mariners game. Is that a defense that could possibly work?
No, it's not going to be a defense that works. Voluntary intoxication is never going to be a defense to homicide. But what he did in his statement, he was very cute. He had some basic details, and when it got to the vital part that the detective wanted to know, all of a sudden he had a blackout. But when you add together the timeline here, what he did unwittingly was tell them that he was at the house earlier that day, and he was with her, and she probably drove him to Seattle. He didn't realize that they were going to find the DNA and the evidence inside the bathtub where the body was cut up. So essentially, he placed himself right at the crime scene, John, and that's a big mistake for him.
So he's implicated himself.
He's implicated himself, and this happens a lot in my experience as a former homicide prosecutor, where people think that they can outwit the police, and they don't realize the police are going to be able to find the body, and they realize the police aren't going to be able to figure out where the crime scene happened. So when he cleaned up well, but what he didn't clean up was the traps and the drains in the bathtub. So he essentially placed himself right at the crime scene.
His own parents have sought a restraining order against their son in the past. They then asked that that be revoked. Is that the kind of evidence that can come into court, or would a judge exclude that?
All types of evidence has the possibility of coming into court, because when you're looking at restraining order, that shows that he had a propensity for violence. And when proving a murder case, in order to show that this person could have done this murder, could have participated in this murder, and had the mindset to hurt or kill someone, violence against your parents is definitely a piece of evidence that could come in.
And they said he was especially prone to violent outbursts when he was drunk.
Yes, and if they get evidence that he was drinking or using drugs during this incident, then just like Bob said, he talked his way into the apartment. So when people talk too much, they oftentimes give themselves up and they put themselves right at the scene and confess without even knowing it.
Perhaps no surprise, Bob, that this guy had a past record. He was convicted of negligent driving in 1998 in Washington State. Aggravated robbery, that's a second-degree felony in Utah back in 2006, felony theft in 2009 in Montana, a battery charge in Idaho in 2009. But those are a long way from the kind of murder we saw here.
Yeah, they definitely are, and that would probably not be admissible unless he took a stand, and then it could be used to impeach his credibility, but it can't be used substantively in the trial, as well as I believe that the incidents with his parents are not going to be able to be admitted at trial, because judges don't want to try cases within cases. What they want to do is go on the facts of that particular case. But certainly as a prosecutor, I'm looking at that history, and I'm seeing a violent history there. I'm seeing repeated contacts, and certainly this is going to increase the quotient in my mind that he may have been the person who committed this particular crime.
Her own family, the victim's family, did some of the investigating here. Her sister found a bunch of texts on the victim's cell phone, that is a bunch of phone calls, actually texted the number, her mother did, and said, "When did you last see her? She's not here, her phone is here, driver's license and purse, but she is not. Please respond. I've called 911. That went to John Charlton's cell phone. He writes the mother back, 911, what's going on? We went to the Mariners game last night, but we didn't stay the night together because she has her kids today. Not sure what she has told you about me and our relationship." Now, as a defense attorney, how would you approach that? Should he have answered that or ignored it altogether?
He should have ignored it. Anytime you communicate about an incident, or especially a murder, that is going to come into evidence. And it's going to be something to help the police as well as the trial court put this case together. A murder case is just like a big puzzle. One piece will fit into another piece. Where were you? You saw her yesterday, which puts him back with her. He should have just shut up, just like the Miranda rights say. You have the right to remain silent, so do it. And if he did not give any evidence, their case would not be as strong.
So employ your experience as a prosecutor. What does that text exchange tell you?
Terrible for him. One, it's giving additional information where he's identifying that he was with her. But more importantly, at a certain point in time, the mother's writing, I'm desperate. Please get back to me. I'm worried about what happened to her. And there's nothing. There's silence. So as a prosecutor, I'm using that to say, why would somebody who has a girlfriend, who's an innocent person, not be responding back and cooperating with the mother who had indicated to him that she had called the police? That to me is consciousness of guilt, as we call it in the law.
Just a very sad story. She has 3 kids, and they are left motherless now. What an appalling crime.
And a gruesome crime.
A gruesome one as well, yeah. Apparently he's going to be in court tomorrow. That's when the clock runs out on prosecutors who want to charge him.
Yeah, and you know what's funny about this case, John? The judge has ordered in this particular case that his face cannot be used by the media.
Yeah.
And I want to just tell you, as a former prosecutor, this is very disturbing to me, and I'll tell you why. The community's eyes and ears and involvement, where was he? Who was he with? They need to see his face. There may be somebody, I've had this happen where citizens call in and say, hey, he was with me, or I saw him somewhere, I know that guy, or I saw him driving his car. Right, Eric? Don't you think that's important?
I do think it's going to be very important, but the judge is trying to err on the side of caution to make sure that there's not an appealable error.
Yeah, but the jury's going to see his face anyway, so I don't get it.
Yeah, it is unusual. Thanks for bringing that up. All right, Bob Bianchi, Eric Guster, thank you.
Thanks, John.
Heather.